Okay, good morning, everybody. Welcome to the second session. My name is Omri Ben Shachar. I'm a professor of law here at the law school. And we'll change a little bit the format of this panel. We have three speakers. Each one will have a 35-minute slot, which we're trying to organize such that the first 20 minutes will be the presentation and then 15 minutes for discussion with the audience, and so that we can direct questions immediately after the presentation to each speaker. Our first speaker is Professor Steve Chevelle from Harvard Law School, and his presentation is titled "On the Limited Utility of Taxes as a Solution to the Externality Problem."
Okay, thank you, Omri. It's always a pleasure to visit Chicago. It seems like I'm visiting my extended family. So I'm happy to be here. It's also very nice to be celebrating a long scholarly career of an individual like Ronald Coase. Unfortunately, even though, well, the unfortunate aspect of his longevity, it seems to imply that we're all getting older ourselves, and I wish that weren't true, but it is. My topic does relate, I think, obviously to Coase's work, his problem of social costs, and he probably would be pleased with the paper because it's another attack on Pigou, in the sense that the paper that I'll be outlining suggests that corrective taxes, which are associated with Pigou, maybe more than Pigou would have liked, but they are associated with him, are not as good a device for curing externalities as they're portrayed to be by economists. So let me explain why. And as background, let me just remark that, and this is not based on any scientific study, but it's an impression which I will try to document. It doesn't seem to me that taxes are used very much at all to control externalities. Obviously, they are used to control certain types of pollutants. We're all familiar with that, and that's an important area of application. But when you think about the vast terrain of activities that can cause harm to individuals, they are very rarely, this is my observation, controlled by what we would call corrective taxes, Pigouvian taxes. They're controlled by other legal instruments. I'm going to be focusing on liability, but of course there's regulation, there's the injunction, there's criminal law. So we could ask ourselves the question, why, despite the popularity, at least within the economics profession, and the general view of economists, although there's some qualifications to it, that taxes are a very good, if not an ideal instrument for correcting externalities. Why is it that they're so infrequently used? I mean, one possibility is the world, for various reasons, doesn't want to use them despite their intrinsic virtues. Another is that maybe they don't really have the virtues that they are generally thought to have within the profession. So what I'll be doing is examining the question, what are the virtues and demerits of taxes, and then of liability as an alternative. And I will offer as a conjecture that the relative infrequency of use of taxes makes economic sense because of the problems with them, and that from the point of view of theory, I'm not at all surprised that liability totally dominates taxation, if we're counting numbers of activities that are controlled by liability rather than by taxes. And maybe or maybe not, you'll agree with me at the end that what we see is in a gross sense explainable. Okay, this is just a slide that says, that makes reference to Coase and to one of the themes in his article, not that bargaining will solve many externality problems, but I would say the second major theme, which is that when bargaining won't solve problems, we can think of government intervention, but the fact that there are tools available to us doesn't mean we should apply them, because they may have costs and they may also not be applied with the kind of information we would like the government to have. And it's those two points that I'll be discussing in relation to taxes and liability. So the first point, and perhaps the most important point of my discussion, will have to do with the definition of the corrective tax. When I was a graduate student and an undergrad and took economics courses, the definition I think I would have produced if you asked me for it was a tax equal to the harm caused by the activity generating a negative externality. So pollution was a stock example, and I just thought, okay, the tax was equal to the harm. But I think on reflection you would say the definition should be the expected harm, not the actual harm. Because when we think about a pollution tax or actual taxes, no one is envisioning that fish that die, people that get cancer prematurely, houses whose paint peels earlier than what would otherwise have been. Nobody thinks that we're measuring the actual losses. Rather, we're using a statistical approach and estimating expected losses. So that would be the definition I take of a tax. And if that's the definition, then the question is, what would be the interpretation of a tax equal to the expected harm for different types of activities? If we take the stock example of pollution, and we think of some pollutant like SO2, maybe the quantity of the pollutant is a very good measure of expected harm. I kind of suspect it is. I'm not sure what else we would measure if we have an idea of the harm that SO2 does generally when it enters into the atmosphere and so forth. But if you ask yourself, what would be the interpretation of the tax for other types of activities? So I'll just pick one almost at random. Operating a crane. You have a construction firm and you're operating a crane. If you want to figure out the expected harm from the operation of the crane, you'd have to know a whole list of things which would be very important to the risk. You'd have to know the physical characteristics of the crane, height and weight, the tensile strength of the cables that are picking up things. You'd have to know how heavy the objects were that were being picked up. You'd have to know about the training of the operators. You have to know about the care that was taken in maneuvering the crane. You'd have to know how many people were exposed to risk. I mean, the list is obvious, and it's clear that if you didn't take into account many of these variables, then your tax that's supposed to, if we were using the tax to control the risks due to crane operation, the tax would be way off if it didn't take into account many of these variables. If you think about other activities, driving, transporting oil, clearing your sidewalk of ice and snow, and you ask yourself, I won't go through it, but if you ask yourself, what do we need to know to measure the expected harm, which we would need to know for a tax, the answer is going to have the same character as in the crane example. Very difficult. It would be very difficult to to get a good estimate without measuring a lot of these variables. So this leads me to make some comments about problems with a tax. Omri, how much time do I have left? Okay. Of course, the standard argument for the tax being a good instrument is that the party making a decision that could cause harm will weigh the benefits that that party would obtain against the harm or the expected harm and make an optimal decision. There's nothing wrong with that argument as long as the person is weighing the true expected harm. So my first comment, which is obvious, is that if the tax for an activity does not really measure the expected harm very well, and I think it wouldn't because of the administrative cost of so doing, for most types of activities like operating a crane, then the tax is just going to be off, and off significantly, and this would lead to all kinds of inefficiencies. So if there was a tax for crane operation and you happen to be using your crane intensively, and the operators of the crane were poorly trained, and there were a lot of people exposed to risk, well, the tax would be way too low for your crane operation. So that's one obvious and I think extremely important count against the tax. A second one is that variables that are not taken into, that would not be taken into account explicitly by the tax would not be controlled by actors and would create excessive risk. So if there was a tax on me as a crane operator and it didn't go up because I chose poorly trained operators to actually run the crane, then I would hire, other things equal, I would hire people who aren't very well trained because it would be cheaper, so that there would be a bias due to unmeasured variables, an upward bias in risk. So even though if the activity level were controlled by the tax, the risk per unit of activity would be inefficiently high. So that's the second problem that I think is of significance. Third problem is the administrative cost itself. I mean, there are two aspects of this. One is the cost of measuring many variables per actor, and the other is the number of actors that would have to, whose behavior would have to be measured and from whom a tax would have to be collected. I mean, there's so many things that we do in life. If they were all controlled by taxes, I think we would be overwhelmed with administrative costs. And when I get to liability, which I will in about 2 minutes, I'll be contrasting the administrative costs of the liability system, which has the signal virtue that it is applied if and only if harm is done, which is, for most activities, an unusual event. Okay, so my conjecture, this is sort of a rough empirical conjecture, is that the problems, these three problems I mentioned that afflict taxes are really bad for most activities, the activities that are in the sphere of tort law. And for peculiar and somewhat coincidental reasons, none of the three problems is that severe for pollution. So I think the tax can work fairly well for pollution. Now let me go on to liability. Omri, how much time? 9 minutes, okay. There are, as probably everybody knows in this room, two major forms of liability: strict liability and negligence. I am going to compare strict liability to the tax. I also have slides comparing the negligence rule to the tax. That comparison is more complicated, and I'm going to omit it from my presentation now, but when I actually deliver to the website the paper I'm working on, the paper will have the missing section on the negligence rule. So let's pretend, even though it's not true, that the major form of liability is strict liability, and compare the performance of strict liability to the tax. Well, it beats the hell out of the tax under certain assumptions, which I'll get to. The definition I'm taking of strict liability is simply, if you cause harm, you pay for it. Now, one comment right off the bat to make about strict liability is that it does not require all the information that is required of a tax authority. You know, the tax authority, as I said, has to measure expected harm, measure all kinds of variables to figure out what the expected harm would be from operating a crane. Under strict liability, none of that is necessary. All that needs to be done is, if there is an accident with a crane and there's, somebody gets hurt, you just got to assess the harm. That's the end. So there's no informational need. Second, there's no problem of untaxed variables not being controlled by parties. That whole issue is mooted because under strict liability, you pay for the harm and you will be induced yourself to control all variables so as to lower your expected liability. Administrative costs. Probably administrative costs are lower under strict liability than under a tax. One reason being, as I just said a minute ago, that strict liability is applied only when there's harm. And so for activities like operating a crane, owning a dog, which might bite somebody but probably won't, owning a cat, which it's hard to imagine would hurt anybody, unless it's a Maine Coon, maybe. The likelihood is low, so the cost will be borne infrequently. The fact that the only thing that needs to be done under strict liability is to measure the harm kind of suggests that the cost, even in an application of strict liability, could be less than for a tax, although that statement has to be qualified because under the legal system, of course, we have all kinds of wrangling that doesn't occur with a tax authority. So that point needs to be qualified. 5 minutes left? Okay. But there are some problems with strict liability, and the two major ones have to do with, first, the possibility that suit would not be likely. Now that can occur for two standard reasons. One is that the victim cannot identify the author of the harm. And this is frequently the case with pollution. You know, you develop lung cancer, but you have no idea whether it was due to smoking or whether it was due to some pollutants in the atmosphere. If due to pollutants, you will have no idea, who the generators of the pollutants were. You might not know, you probably wouldn't know who to sue. So therefore, this compromises the functioning of the liability system. Second standard reason why you might think suit might not be brought is not that you can't identify who did it, but that the magnitude of the harm is below the cost of the bringing of suit, and therefore suits might not be brought. Of course, we have the class action as a device to ameliorate this problem, but it's still a problem. And I think if we ask about pollution, both of these problems for different types of pollution are important, and therefore it doesn't seem that the problem of pollution would be that well controlled by the use of strict liability, whereas, as I suggested, the tax probably does a reasonably good job. The other problem is the judgment-proof problem that the injuring party might not have enough money to pay, and obviously that can dilute the effect of liability. It's not as much of a problem for taxes, because taxes being based on expected harm don't require the party to pay as much money as the party would have to pay if the party had to pay harm. The probability times harm is a much smaller number than the harm if the probability is low. So this is a list of factors that, to me, in a rough way, suggest that reinforce what I said about when I just cataloged the pluses and minuses of taxes, reinforce the conclusion that pollution seems to be well controlled by taxes, would not be well controlled by strict liability. For the other activities, the opposite seems to be true. Let me wind up. I'm skipping my slides on negligence, which, as I said, is more complicated, with two comments about the possibility of using taxes and liability jointly. First, let me say there's a potential problem with that, which is double billing. If we did impose a tax equal to expected harm, and we also impose liability, we would be making parties pay for more than the harm they did, and possibly twice as much, which would be a bad thing. We would be chilling desirable activity. So any combined use would have to be pretty nuanced. Is there a reason for combined use? In theory, there might be, because under strict liability, we have informational advantages that I articulated, and therefore we might want to use strict liability, but we might not want to rely on it because of the problems of attributing harm to the creator of the harm. So it's very easy to construct examples in which we would want to use both. My conclusion is, though, that the main conclusion is that when you think about what corrective taxes really mean and how they should be interpreted as equal to expected harm, once you realize that's their definition, has to be their definition, then you can understand why I think they're so infrequently used. And I would hope, but I don't really expect, that economists will pay more attention to liability than they do now when they hardly mention them. They seem to talk about taxes and regulation, but they leave out poor liability. That's the end of my presentation.
We have 15 minutes for questions. I would like to ask the first questions and open it for everyone else. Many of the activities that are controlled by liability the actors are able to buy insurance, and in fact, many of the actual risky conducts that would give rise practically to liability are insured. It is striking that insurance resembles in many ways a tax system where you pay upfront for the expected harm, and that the insurance companies both manage to solve the informational problems to make this work, and that we are not seeing a situation where people are just subject to too many taxes. They buy a few insurances for professional liability and the ownership and operation of assets, but by and large cover most of the risky activity that would be subject to the liability scheme. That seems to suggest that a tax system that would mimic something of what is done correctly by the private insurance market could at least potentially work and not be subject to the same failures that you identified. Is that true?
I don't know. Just a reaction is that I believe that when insurance companies price insurance and ex ante, they don't look at, just for the average person, a whole list of variables, but they look at some. And I think that's exactly what would happen if we had a tax system. And what insurance companies also do is that when there is an accident, they sometimes do subsequent investigation. And in this sense, they're doing what the tort system does. They are saving administrative costs by inquiring into the details of your behavior. Did you really have a fire extinguisher? You said you did in your insurance policy. Did you, the policy says you weren't supposed to have had oily rags around that might have caught fire, and you said you weren't going to have them. The insurance company comes in if there's a fire, checks out the situation, investigates then. So it's able to, function relatively well by using some of the tools of the tort system. But the tax, by definition, couldn't do that. It has to operate on every single person ex ante and come up with a number that person is supposed to pay to correct the risk. I'm saying it's just too expensive to be done. Evan.
Well, I just want to point out something which I'm sure you know, and maybe it's just a slide that you didn't cover, but we do have widespread use of these quantity restriction rules, which say, you can't walk your dog, in this neighborhood after some time. Your trainers have to follow certain kinds of safety standards, and there are fixed rules. And putting aside, Weitzman's prices versus quantities, those rules are really based on expected harms. So the argument, that we don't see the taxes because you have to do sort of, an expected harm calculation actually applies to something that we see more widely used than either taxes or liability rules, which says thou shalt not drive more than 55 miles an hour, and so on. And that's all based on, in some principle, expectations of expected harm.
That's a good observation. If I can just restate it, you're saying that we're awash in regulation, which is an ex ante form of control, and the information needed by a regulator is arguably at least as much as the information needed by a hypothetical tax authority, because the regulator has to figure out the optimal action, not just the expected harm. So I think you're suggesting it's inconsistent of me to say, how could we have a successful tax system when you're kind of suggesting we have a successful regulatory system? Is that?
I'm not saying it's so successful.
Okay.
But I'm just saying that, if you're trying to explain why we see liability and not taxes, it's not fully, then how to explain all the regulations.
Okay. Well, my answer is, and it may not satisfy you, but that regulation is generally kind of crude, doesn't control more than a relatively restricted list of variables. And it can be that way because it's supplemented by liability. So we really have a joint system of regulation and liability. And so, that is why I think the regulation can be relatively crude. But if we had only a tax system, and it was as crude as regulation was, I think we would be in very bad straits. George.
Steve, I really wonder how consistent your approach is with Ronald's approach. I had to read from as I recall, he was just as critical of liability rules as he was of taxes. And her point that if the tax authorities get the tax level wrong, you're going to have lots of inefficiencies. Well, that just seems to be just exactly opposite of Ronald's. Part of what Ronald was looking at, but Ronald could have as easily rewritten the paper to conclude in the absence of transaction costs, the level of taxation will have no effect on the allocation of resources. I think he's just as skeptical about the allocation of liability and its ability to achieve efficient results as he is of taxation. But also, I think Evan's point is even stronger. Regulation is much harder. It's much harder, in fact, in many cases impossible to negotiate out some regulated, mandated form of safety. So I agree with Evan, it's the ubiquity
Of course, I don't know exactly how Ronald would feel about certain conjectures I have, and I didn't mean to suggest that he would necessarily agree with them. I just thought he would like one dimension of what I was saying, which was the criticism of the tax, not necessarily that he would like my championing liability. But I do think that since if suit were to occur with high frequency, that liability does have an administrative appeal because it's simple. You just, if I'm talking about strict liability, you just measure the harm, whereas to apply the tax is a huge problem because you have to look at this whole long list of variables, and you have to know the function that translates the list of variables into the expected harm. It's just a nightmare. Bill.
The problem, Steve, is that Coase is like a colt. So if you deviate in any little way, you're going to be attacked by this.
I thought it was constructive remark.
I think you probably will deal with this in the paper, but Ronald emphasized, and when he was talking about liability rules or who should pay the harm, he emphasized the reciprocal nature of the harm, and that it was superficial to say that if B causes harm that injures A, the efficient solution was to make B pay for the harm. And as Ronald emphasized, the alternative, the possibility that the most efficient solution, for example, was for A to undertake some behavior to alter the harm, either to avoid being in the area where B was conducting the blasting or to engage in some other behavior. So Ronald emphasized the reciprocal nature of the harm, but I have a feeling when you start talking about negligence that you're going to make that point. I mean, it's not a point that's new to you.
Right. I mean, of course, I know there are multiple themes in Coase's article. That's for sure one of them. My reaction to it is that it's almost orthogonal to my project because under liability, we of course have defenses of contributory negligence, both under strict liability and negligence. So there is a significant way, at least in principle, for us to control behavior of victims using liability. And under the tax, of course, the victim has an automatic incentive.
That's what I mean. I said I was assuming we
Yeah,
were going to discuss
yeah.
this. You just didn't do
Yeah.
it for this presentation.
Dick.
This is a little related to what George said. Suggestions related to George's, which would be to discuss the different institutional structure of liability and taxation. Because the liability rules are administered to a large degree created by the judges, and the tax system is created and administered by the legislature and regulatory agencies. And, they're both engaged in a political and legislative process, but, with different incentives and different knowledge. So the judges learn a lot about, for individual cases. Tax authorities may learn a lot about more systematic studies that are subject to more different kinds of political pressures. The other minor point that Bill said, Bill Bowell has an article about how Peruvian taxes can be modified in order to place incentives on potential victims. So as long as they have zero tax, then the victims have to do all the acts of collusion avoidance and the injuries of the victims. So I'm not sure that's critical.
Thank you. Yes, I don't know your name.
Peter Grant from the University of Maryland. So to make your point, perhaps with
But we have the close cousin often of trading in rights. It's not really the same, but it's in spirit in many respects. It's quite close. Gary.
One reason we don't use tax on pollution is because the people being taxed don't like it. And that's the reason why instead of selling quotas, we give it away to it. So there are the political economy aspects of it. I think even when you deal with pollution, let alone these other areas, are extremely important. And I would add to that, many people are concerned, you do have a tax or an auction on treating them simply. What's the government going to do with the money? Economists like to assume, well, the whole total government spending constant and this replaced another tax. But in fact, all the empirical studies I know of show the government ends up spending more resources than they could spend beforehand. And a lot of people are concerned about that. So you have two issues. The people being taxed don't like it and they're politically important. And then maybe as outsiders who don't like it because of observing what the government will end up doing with greater total revenue. So I don't know how you deal with that, but that applies directly to pollution. And I agree with a lot of the other arguments that alcohol, a lot of the other grenades, or the tax on alcohol.
Right.
I want to drink a day, what are we taxing them for? And it's that way close. But even in the pollution area, there are issues why maybe you don't see the tax, maybe you don't want it.
I agree with that, and you ask, what am I going to do with it? That's going to be in my conclusion, where I talk about other important positive explanations for the relative rarity of use of taxes. But what really sort of inspired me to think about this topic was just the realization that, gee, taxes are supposed to be this wonderful animal. How come we never see them? And when I started thinking about, first example I thought about was shoveling snow and ice. I said to myself, what in the hell is the tax going to be? I mean, do we imagine somebody's going to come around and measure the amount of snow and ice? And are they going to take into account melting? Are they going to check to see whether I put sawdust and salt on it? You have to do all of that to apply a tax. It's just, it's crazy. So that's really what I was thinking about. Okay.
So thank you very much. Our second speaker is Tom Mayer from Yale Law School, and the title of his talk is Coase and the Mental Picture of Property Rights.
It's especially gratifying for me to be invited to speak at this conference. As you can tell by the fact that the PowerPoint's been turned off and that I have my paper on yellow pad, I'm a lawyer by training, not an economist. But I did get my legal training here at the University of Chicago Law School. And I think that maybe one of the catalyzing events that led me to want to become a teacher was in my first year at law school, Bob Ellickson, who was visiting here, convened a panel discussion for the benefit of the first-year class, which consisted of Richard Posner, Richard Epstein, and Ronald Coase. And they were to debate among themselves the fundamental premises of the tort system. And so Posner articulated the negligence principle and economic efficiency, and Richard Epstein, at least back then, articulated a kind of corrective justice theory, and Ronald Coase said very little. But what he did say, I recall, was that you should think about contracts as a possible solution to these problems, as well as torts and liability. What I'm going to talk about today is the third leg of the stool of this conference, which is not firms and not markets, but property rights. And I don't pretend to be a polymath like some other people in this room, but it's distinctly my impression that Coase's work may have had a more profound impact on property and on the economic analysis of property than on any other field. And I think this is a paradox. I'm going to talk about a couple paradoxes, one of which I sort of explained, and the other one I'm a little bit mystified by. The one I'm still sort of mystified by is the fact that, as the video we saw yesterday indicates, Coase really didn't think he had anything to say about the structure of legal rights. He was not terribly interested in that. He wanted to influence economists, not lawyers, as Bill Landis has emphasized. And so the fact that his work, particularly his 1960 article on the problem of social costs, has had a profound impact on property theory and the economics of property is particularly interesting. If you want evidence of the influence, let me just cite very quickly two things. One is Professor Harold Demsitz's 1967 article, Toward a Theory of Property Rights, Toward a General Theory of Property Rights, I think it was, which I think is directly builds on Coase's 1960 article. One way of reading Coase's 1960 article is that Coase was explaining how contracting can solve problems, externality problems. Not solve, they can internalize externalities, excuse me. And I think Harold's 67 article really takes that insight and then also demonstrates how the creation of property rights can internalize externalities, subject to constraints about enforcement costs and the benefits of internalization and so forth. But I think that you can see it, trace a direct line of influence from Coase to Demsitz's extremely seminal article on the evolution of property rights. The other example would be the 1972 article, which also appeared in the Landis PowerPoint, Calabresi and Malamud's article on property rules, liability rules, and inalienability. Here I think the line of influence is Coase's emphasis on transaction costs, and Calabresi and Malamud basically identified liability rules as a distinct mode of protection of property rights, which appears in circumstances of high transaction costs. And that framework has been enormously influential in the economics of property ever since. I'm going to focus on a second paradox that I think Coase's work presents for property theory, which is that Coase's work, particularly his 1959-1960 articles, is based on I don't know quite how to put this politely, what I regard as a misleading mental picture of the institution of property. Coase adopted as his mental picture a thoroughly modern notion of property at the time he wrote, essentially the idea of property as a bundle of government-prescribed rights. And in this respect, he was in keeping with the times, but I will argue that in fact this was not the best model or the best mental picture of property rights for building an economic analysis of property going forward. Now, if you go back before Coase's time, which I guess is 100 years ago, the dominant mental picture of property rights was a sort of image of mini-sovereignty. So just as the king was thought to be the ruler of all of the territory in the realm, each owner of property was thought to be a little mini-king of whatever thing it was that they happened to have ownership rights over, whether it be Blackacre or whether it be a physical chattel or whatever. Blackstone captured this image or mental picture quite vividly in his commentaries when he spoke of property as that sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the world. So this image of the sort of sovereign power of the owner comes through clearly in Blackstone. And I would point out it's also present in other writers up to the time of roughly Coase's birth. The notion of ownership as a type of sovereignty was an exaggeration, as many people have pointed out, but it had one virtue, which is that it captured the idea that property is an in rem right. Now, what do I mean by that? I mean that property rights attached to things, rem is Latin for race or thing, attached as a matter of law, and they impose duties of non-interference or abstention on, quote, all the world. So in rem rights are not contractual, they're not in personam bilateral rights, they're not rights created by judicial judgments, and they're not rights created by some kind of legislative regulation. They are rights that are broadcast from owned things and impose negative duties on all the world not to interfere with or intrude upon the owned thing in impermissible ways. And in rem rights do not require that you know who the owner is. They don't require that you know what form of ownership it's held in, and they do not require that you have any concept of what the owner intends to use the thing for. Blackstone was not alone in adopting this sort of implicitly adopting this in rem conception. It's also can be found in a number of economic authors, including Adam Smith and Bentham. But about the time of Coase's birth, an attack was mounted on the idea of property as mini-sovereignty, and it was waged primarily by a group of American academics known as the legal realists. And the realists offered a competing mental picture of property, which was the picture of property as a bundle of rights, or a bundle of sticks. And the idea was that property is just a label that we attach to a collection of rights and obligations that attach to ownership of particular things, and that the sticks in the bundle can be added or taken out more or less at will, and that the sticks in the bundle can vary from thing to thing, place to place, person to person, and that the people, the person, or the entity that puts the sticks in and takes them out is the collectivity, usually acting through the legislature, although it can also be through the courts. Now, the motivation that the realists had for offering this competing mental picture of property was entirely political. They thought to deprivilege, to use the current trendy term, property rights, or perhaps, given my thesis more appropriately, to dethrone property rights, in order to facilitate more activist regulation of property, and particularly redistributive legislation. But the bundle of rights had the side effect, the bundle of rights picture has the side effect, whether intended or not, I think, of also obscuring the in rem nature of property and making it seem like something entirely different from the traditional in rem picture of property rights that had preceded it. Coase, being a man of his times, and I think also perhaps being relatively uninterested in legal ideas, adopted what I think was something very close to the bundle of rights idea. He never uses the phrase, as far as I'm aware, in his writing. And I certainly think he had no sympathy with the legal realist program. Coase's point, obviously, was not to enhance collective authority over property, but rather to encourage contractual exchange of rights as an alternative to collective regulation. Nevertheless, I think Coase adopted a picture of property in which use rights in things are prescribed by the state on a more or less ad hoc basis, and that these use rights, once they've been adopted, can then be used as the basis for exchange. My evidence for this is textual. If you read Coase's articles in 1959 and 60, you can see clear evidence of this particular understanding. Let me just quickly read you or talk about a couple of passages. One occurs in the very last page of the 1960 article, The Problem of Social Cost, where Coase is wrapping up after having described in some detail English nuisance cases and having suggested that to some extent English courts are trying to reach judgments in those cases that maximize the joint welfare of two parties with incompatible land uses. He then offers this observation. He says, what does not seem to have been, wrong page. He offers the observation that the rights of a landowner are not unlimited. It is not even always possible for him to remove the land to another place, for instance, by quarrying it. And although it may be possible for him to exclude some people from using his land, this may not be true of others. For example, some people may have the right to cross the land. Furthermore, it may or may not be possible to erect certain types of buildings or grow certain crops or use particular drainage systems on the land. This does not come about simply because of government regulation. It would be equally true under the common law. In fact, it would be true under any system of law. A system in which the rights of individuals are unlimited would be one in which there are no rights to acquire. And then he sums up by saying, we may speak of a person owning land and using it as a factor of production, but what the landowner in fact possesses is the right to carry out a circumscribed list of actions. So that, I think, is pretty close to the bundle of rights idea. It's even clearer in the 1959 article in the Federal Communications Commission. There, Coase had the task of justifying the use of property rights in the spectrum, which would then be exchanged in the market as a superior way of allocating the spectrum to government regulation. And so the task of describing these property rights was much more front and center than it was in the article the next year. In so justifying the use of property rights, Coase had to confront a variety of arguments to the effect that private property rights in the electromagnetic spectrum are too difficult to define and enforce given the invisible nature of the resource and the limited understanding of the circumstances in which one type of broadcast activity will interfere with another. He sought to rebut these arguments by suggesting that privatization should proceed not by defining exclusive rights in some portion of the ether or in particular broadcast frequencies, but rather by specifying use rights and broadcasting equipment. Let me read you a passage. He says, what does not seem to be understood is that what is being allocated by the Federal Communications Commission, or if there were a market, what would be sold, is the right to use a piece of equipment to transmit signals in a particular way. Once the question is looked at in this way, it is unnecessary to think in terms of ownership of frequencies or the ether. So again, Coase has tried to shift the focus away from the conception of some type of right to exclude the world from a particular owned asset to a list of government uses. Now, I think to a large extent, this image of property that Coase has, at least when writing these seminal articles, obviously didn't interfere with his work making a tremendous impact on property scholarship, particularly insofar as Coase focused on exchange of rights and the importance of exchange of rights. I think his work continues to have extraordinary impact. Let me just mention very quickly some areas where I think his work and property has benefited property theory enormously. One would be our understanding of certain legal institutions that facilitate exchange of property rights. And all I have to do is refer you to a couple of presentations yesterday, Gary Liebkap's presentation on the land surveying system and its superior attributes for defining and enforcing property rights and facilitating exchange of rights relative to the metes and bounds system, or Sebastian Galeano's paper presenting evidence about land titling and registration and its impact on wealth and economic activity. So both of those are examples of how institutions that facilitate exchange of rights are pro-efficiency. I would also point out that there's this burgeoning literature on anti-fragmentation rules, sometimes called anti-commons rules, which I think again flows directly out of Coase's orientation toward the importance of exchange and exchangeability of rights. And lastly, but not least, Coase's whole focus on comparative institutional analysis and the importance of comparing liability rules, government regulation, and contract has been extremely influential with property scholars. Virtually everyone today in property, for example, recognizes that covenants are alternatives to zoning or nuisance law in regulating neighborhood spillovers. Notwithstanding all those positive things that Coase did, I think there are at least four areas where his implicit mental picture of property as a bundle of sticks or a list of government-prescribed use rights has arguably retarded or perhaps inhibited the development of property theory. First of all, if we think of property as if we understand property as an in rem right, a right that imposes duties on all the world to desist from certain types of interfering acts, it becomes quite obvious that property, at least in its everyday sense of possessory rights, imposes an enormous information cost problem. Everyone in society has to be able to recognize owned things and has to be able to orient their conduct in such a way as to not interfere unduly with these own things. And that requires that the triggering or signaling conditions for identifying property rights be extremely easy to understand, and that a third grader can basically comprehend how to navigate through the world of property rights. So complicated legal ideas like keep off and don't take have to be central to the institution of property. And I think if we think of property as a bundle of rights or a bunch of government uses that vary from case to case, that feature of property rights becomes obscure. Secondly, the in rem feature of property helps explain why property does not come in infinitely customizable bundles of rights, but in fact comes in fairly standardized bundles. As Henry and Smith and I have written in some articles, property is subject to what the Europeans call the numerus clausus. There are limited numbers of forms in which people can own property rights. I think this feature can be explained by the fact that there are potential transactors in property rights, lenders, leasers, licensees, and so forth, and they have potentially high information cost burdens if property comes in infinitely malleable varieties, and so limiting the forms of property is also necessary to reduce transaction costs and information costs for those parties. This feature, again, is somewhat obscured if we adopt the mental picture of property as a bundle of rights. The third point I would make, and I think I'll bring this aircraft in about on time, is that the bundle of rights picture doesn't really capture the central function of exclusion rights to the institution of property. The in rem understanding, the old-fashioned mini-sovereignty concept, puts exclusion front and central. The little mini-sovereign has the right to exclude the world. That understanding makes it quite comprehensible that property is a system for managing resources in which is highly decentralized, that individual manager owners have high degrees of discretion about how assets are used, who gets to use them, and so forth, and that this system is really critical to the dynamic efficiency of a private property system, because the owner-manager with the right to exclude can basically capture the residual gains from all sorts of management activities and investment activities that take place regarding the property. Whereas if we adopt the bundle of sticks metaphor again, exclusion is just stuck in the bundle along with a bunch of other rights like the right to inherit and so forth, which may not be nearly as central. And that image tends to obscure the kind of dynamic efficiency that's associated with property. It's a little bit like Bob Cooter's point yesterday, that we have to think about dynamic rather than just static efficiencies. And I think the in rem concept leads us more readily to that sort of insight. The last point I would make, perhaps most controversially, is that the in rem nature of property rights makes it somewhat, not scratch somewhat, it makes it implausible to accept Coase's assertion that entitlement, that there's no point in talking about causation in considering externality type problems. And why do I say that? Well, it is plausible to think that cause is reciprocal if you talk about certain types of accidents, you talk about neighborhood spillovers. But if you think of property as in rem rights, in which on the one side you have the owner, on the other side you have the entire world of potential violators or intruders on the property right, it doesn't really make a lot of, it's not very helpful certainly to say that the problem is reciprocal and that if transaction costs were zero, the problem would necessarily go away. Think, if you will, of the situation where you own a car and you live in a neighborhood where there's a bunch of car thieves, and the issue is whether or not you have the right to the car, and anybody that wants to take the car has to purchase it from you, or whether everyone has the right to your car and you have to buy them off to prevent them from stealing your car. I don't think that, certainly the transaction costs are not symmetrical in that case. If you grant ownership rights to the car to one person and force everyone else to pay them for the rights to use the car, the transaction costs will be a lot lower than if the owner of the car has to buy off every potential car thief from taking the car without the owner's wishes. And so it seems to me that at least when we understand that property rights, and I would say also rights of bodily security, have this in rem feature, they bind the entire world, the symmetry point, reciprocity point, breaks down, at least in cases of intentional harms. And this is another aspect in which I think at least the failure to recognize the in rem character of property rights may have diverted us a little bit from correct understanding of property. Thank you. You want to call people? Richard?
Yeah, I agree with much of what you said, but I have one strong disagreement. And I do not think that the notion historically of a bundle of rights was inconsistent with the sovereignty position. Understanding Roman definition of property rights with universal rights to exclude, to dispose, and to use, subject on the use side to the like use of others. I think the realist problem was that they thought that this was an arbitrary assemblage of bundles. We could take one in and out. And the Roman position was always they were part of an indissoluble whole. And one way I could say that I think this is correct, when you mentioned you wanted to put exclusion front and center, I guess you did in your Nebraska article. And that's great if exclusion gives you a right to use and develop on any question, which you talked about management of investment activity. But if you take the modern view, which I think is much more destructive than anything that Coase said, that exclusion is the right and that every right on use and disposition is subject to government veto under a regulatory takings doctrine. That's where the whole thing starts to blow up. And so my sense about it is that I think it's wrong to fight this. On the bundle of rights issue, I think the right thing to do is to explain why you make this particular bundle. And Coase, although I think you get wrong on reciprocal causation for the reason that you said at the end, if you look at this assembly of rights, there is no way you can configure rights with respect to standard lanes of first approximation, which will minimize transactions clause between an owner and the rest of the world. And the physical invasion boundary conditions comes out as the dominant constraint, but not the only one. For example, interference with advantageous command, which is a long-established court, is only intelligible if you have a right to dispose of property getting who you see fit on a mutual agreement. So I don't think that the realists made any gain by pointing to a bundle of rights. I think what they got wrong was the idea that somehow this was arbitrary, and that's because they had no theory what property right is supposed to maximize. So I have a different critique of them from what yours are, and I wonder whether or not you think that this is consistent or inconsistent with your views.
Well, yes. I think I don't go all the way with you in suggesting that there is some kind of inherent trinity of rights that ownership necessarily entails. I do think that, to me, the critical difference is really between the in rem understanding and some other understanding of rights of property as just being what sort of a zoning board gives you in terms of you can use A, B, C, D as their permissible uses, and you can't do E, F, and G. And I do think that exclusion is key because I think exclusion, absent positive regulation of particular uses or of transferability, gives you, by implication, an open-ended set of use rights and transferability. So maybe that's just a quibble. But I do think that I would put the emphasis on the fact that the in rem conception generates these sort of informational cost problems and generates these other aspects of property rights, which the bundle of rights conception is just a package of sort of placeholders that the government speaks.
I think the reciprocal notion of causality is reciprocal runs out in any situation. You can have a case where there's no crime without a victim, right? So one way you can prevent crime is you just have two victims. You say, you have to lock your car, make that a law when they reduce crime now. So it's always a question of which is the cheaper, more effective way of eliminating some unpleasant interaction.
I agree with that point, that we could sort of, instead of having pollution controls, we could have people wear, suits that keep pollution from coming into their bodies and so forth. That's absolutely right. I guess the point I'm trying to make is that it seems to be implicit in Coase's discussion, and maybe I'm wrong about this, but it seems to be implicit in his discussion that not only is cause, it's not worth talking about cause because, it's either A or B can make adjustments to overcome the problem, but that the transaction costs will be the same without regard to where we place the rule of law. That, it's a matter of indifference where we place the rule of law. I think that's what he's suggesting, at least. And I don't think that's right, because I think anytime you have an in rem right, which could be a right of bodily security or a right of property, I think the transaction costs are going to be radically asymmetrical depending on where you put the right. Now maybe that's going beyond what Coase was trying to say, I don't know. And I agree with you as a matter of regulation that you can certainly impose duties on victims as opposed to perpetrators, or as a matter of liability rules you could do that if it's cheaper to do it that way. But I just think as a matter of using talking about exchange and the feasibility of exchange as a way of moving the allocation of rights to higher uses, that this asymmetry that in rem rights features is critical to our understanding of how we can structure things so that that sort of exchange process will move forward in a more satisfactory fashion.
So Dempsey.
I think the in rem rights approach faces some of the same problems as the bundle of sticks approach does. I'm not sure a long time ago in the paper about this variation of transaction costs depending on who owns the right to use a resource. And the example I came up with is the world before the airplane and the world after the airplane. And if we were to continue to hold the notion of an in-rem right to all this airspace, this amount to the center of the earth, then the airlines would have to purchase all these series of rights. We have this composition problem that we're talking about, the auction theory, or whatever the case may be. It's a very complicated, costly arrangement. So in that case, I don't know exactly how it happened institutionally, but the airlines got the right to travel on upper airspace. Okay. Now my point is, it could be just a shift in the in-rem rights. Whereas the rights to travel, the airspace, the owner of the airspace, the airplane is traveling, could be treated as an in-rem right just as well as the landholders' right to be treated as an in-rem right. So where you position the in-rem rights could have the same kind of consequences for transactions cost as you're using the bundle of sticks approach, having more ability.
No, I certainly agree with the point that even if we recognize that property rights have this in rem feature and that they presumptively include exclusion rights, so you can imagine situations where the exercise of those rights are going to produce enormous transaction costs, which are going to interfere in some sense with desirable social outcomes. So the airspace is really just a further variant on the navigable river, where if the riparian owner along the banks has the right to own the bed of the river and can exclude anybody from traveling up and down the river, then you have I guess it's the Rhine River back in the Middle Ages. It's sort of a nightmare for commerce, because every landowner becomes a bandit that holds up everybody that's trying to transport goods on the river. And the same is true with airspace. If the ad Callum doctrine, the ownership to the heavens, extends to the navigable airspace, then we would have a transaction cost negotiating nightmare. It's the same problem that Google Books has run into and things of that sort. So I recognize all those problems. I don't think that really is a function of the in rem right or the exclusion right. I think that's just a situation where it's an assembly of rights problem, where in order to have like highways of commerce and things that allow us to interconnect our property rights, we need to create exceptions to exclusion rights, either by eminent domain or by creating some kind of inherent public right to certain resources that allow people to interconnect with each other.
Time for one more question, Steve.
You made a comment that it might be desirable to limit the number of forms of property rights. That made me, as an economist, think, well, wait a second, why do we want to interfere with the ability of people who often would be in a contractual relationship to construct a new form of property right, a new kind of timeshare or something like that? And So you're saying that other folks won't understand the form of property right? So
It creates an informational externality in the sense that...
Can't you just, I mean, intuitively it doesn't seem to me, maybe, I know you've thought about a lot of this, but it doesn't strike me as a big externality, whereas the need of people to create new forms of property rights would often, I would think, be great. And then one other comment, and it's my last, is that if there is an externality, even though I was, complaining about corrective taxes a while ago, couldn't you just say, all right, if you want to construct a new form of timeshare, because you're going to confuse people out there who might want to buy your timeshare, you have to pay a $25 fee or something with the registry. I mean, why wouldn't that be the answer?
You can measure those costs easily, can you? Right. No, I sort of agree with you. My current thinking about some of these problems is that, it's sort of useful to distinguish between what I would call everyday property, which is, you go out into the parking lot and you try to figure out, what all these vehicles mean. Do they mean, I'm free to take anyone that I can hotwire, or do I have to only sort of look for my car? And I think in that context, we have to have extremely clear, extremely simple, rules that idiots can understand in order to survive.
But we have zip cars. You just look, you see it's a zip car.
Right. Yeah, right. The world changes. But anyway, and then I would distinguish from that to sort of what I would call a transactional context, where we're worried about lenders taking security interests, and we're worried about people taking out leases, and we're worried about people buying and selling assets. And I think a much higher degree of informational complexity is obviously sustainable in that context, because people spend time investigating the rights before they make these commitments, and so it's worthwhile to permit a greater degree of variability in the forms of rights that we have for those purposes than it would be to permit wild variations in ordinary possessory rights. That being said, though, I do think that there are genuine problems if you allow individuals to create highly idiosyncratic rights that haven't been encountered before, because other potential transactors that encounter this, say doing a title search, for example, will be stumped by what this is. They won't really quite understand its implications, and so you'll have very high costs of trying to interpret that. And the frustration on the other side of forcing people into these forms is not all that great, because if you've studied first-year property, you will know that the estates and land system is one where a clever lawyer can kind of manipulate in order to create practically any sort of entitlement that they want to. The advantage of following the forms is that then some other well-educated lawyer can decipher what's being done with a relatively high degree of confidence.
Right, but you have a huge incentive.
It's not the language in that sense.
Yeah, but you have a huge incentive, just like, we're all speaking English because we want to be understood. We don't capture all the benefits of communication, but we get a lot of them. So I would think, I just don't.
No, that's right. Most people would have an incentive to use relatively understandable forms, because that would enhance them, the transferability of their own rights. But there may be individuals who, for whatever reasons, promoting some kind of idiosyncratic end or family dynasty or something, want to create some kind of highly unusual right. And the point was that when they do that, they're not just simply affecting the transferability of their own asset in the future, they're affecting the information cost that other people will incur when they do investigations of rights. And that, we have a sort of social interest in sort of cutting down on that kind of informational externality.
Thank you very much. Our final speaker on the panel is Mike Levine from NYU. The title of his talk is Regulation and the Nature of the Firm, the Case of the U.S. Regional Airlines.
How do I move from slide to slide? Oh, with this, okay. Voila. If I were 35 years younger, I would have an all singing and dancing slideshow. What you're going to get is a few bland black and white slides, because there's a fair amount of detail I want to go over. First, I want to thank the organizers very much for both inventing the conference and for inviting me. I was here in 1967, 68, as a law and economics fellow, in effect a research fellow for Ronald, as George was. research fellow is really the wrong word because I didn't do any of Ronald's research. I did my own research under the misleadingly mild eye of Ronald. That is, you would do work, and Ronald would smile at you, and then you would bring it into his office, and he would tell you it was not quite right. And after a while, you understood that in his vocabulary, not quite right meant what I would say was very wrong. And you would then go through another iteration. I will say also, though, for Ronald and for the University of Chicago, that year was probably intellectually the most influential year of my life. And as I have proceeded as an academic, it was at the very beginning of my academic career, as I've proceeded as an academic, I have understood better just how much it influenced me. And as my work has moved along, in some ways it looks not necessarily more like Ronald's, but more like the work Ronald claims that he would like to see done. And as was discussed yesterday, that has moved it a little bit out of the mainstream, certainly of what economists do. Now, am I changing slides without knowing it? Yes. There we go. Okay. I also, at this point in the morning, want to say that I wish I'd had Tom Hazlitt write my material for me, because it's a long morning and I'm on last. Let's talk about a very particular industry and a very particular set of arrangements that I think illustrate an important point that Ronald makes almost in passing in the nature of the firm. He says at one point in a couple of sentences, and I'm sorry, I should have put the quote up, that the regulation and taxation regime may affect the choices that one makes in economic organization. And I want to argue here that the regulation regime can be incredibly important, and that also a feature that he doesn't really discuss too much, although he mentions it, which is the process by which you contract internally in a firm for factors of production becomes very important. In this case, we're going to talk about pilot labor. These are labor contracts which are regulated to some extent. They've been heavily influenced by regulation, and they are embedded within the firm in a way that has greatly influenced first choices. So let's talk about what we're talking about. An airline system is a network that consists of routes like, say, New York to Chicago, and maybe routes like Chicago to Iowa City. In the early days, the fact that the routes varied enormously in density didn't matter too much if the unit of production was a 14 to 21 seat airplane. And again, if I had something like the Easter Bunny slide, I would show you pictures of airplanes right now, but I don't. And the importance is that passenger journeys don't always take place only on high-density routes, where density means the expected number of passengers per flight. They take place on low-density routes as well, and they're interconnected as part of a transportation system. Now, how you link those together by institutional arrangements has varied enormously over time, and has ranged historically from much of this transportation being provided either by a single firm or by a single firm interacting with another single firm according to rules that were rigidly prescribed by regulation, to a wide variety of institutions that I'm going to show you this morning. The single firm agreement disappeared over time, in part because marketing economics of scale and scope were suppressed under regulation because you couldn't choose which routes you could fly, and have been exploited to a great deal under deregulation. So this is a quick tour. Am I in the way? A quick tour of the currently existing arrangements to link what I call network airlines here, big airlines, to airlines called regional airlines, which tend to specialize in either serving smaller cities or, as in the case of, say, Delta flying between New York and Chicago, two markets in which it doesn't have a great presence, to fly low-density flights that you expect to attract relatively few passengers, even though the route may be a higher density route. Now, the arrangements involve a service dimension, a scheduling dimension, including a choice of frequency. They include pricing, and the obvious and most easiest way to exert complete control over that is to have a wholly owned firm, a single firm, not even a subsidiary, which may produce agency problems more severe than the agency problems you experience inside a firm. For reasons I'll explain in a couple of minutes, that model has disappeared completely, and that has to do a lot with pilot labor contracts and technology. So the next best thing is a wholly owned subsidiary that works under a separate labor contract and supplies this transportation on terms entirely dictated by the parent. That is, they fly with the parent's brand on the plane and with a level of service specified by the parent, and in markets, on schedules, all dictated, and prices dictated, and the interchange prices between service provided on one segment and another are obviously dictated by the parent, who in effect is keeping both the revenue and cost. The next thing you can do is an attempt to reduce the capital burden and also to try to preserve the separateness of the labor contracts. For reasons I'll come back to, internal union politics may produce real problems in having the same firm operate small aircraft and big aircraft. So one of the ways you try to reduce those influences is by having a partly owned subsidiary. You still control the pricing, the schedule, the branding, and all the rest of it, but the activity occurs at semi-arm's length because you have a fiduciary duty to the minority shareholders, and you need to do things on a more transparent basis than you would have to do with a wholly owned subsidiary whose features are just consolidated into your own reports. But there are reasons related to factor purchases inside the firm and also to capital supply to try to do things that way. The next arrangement we see is an independently owned regional airline that behaves like a partly owned subsidiary in the following sense. It usually uses airplanes supplied by the parent, and that's for Williamsonian hold-up reasons that I'll be discussing in a minute. You can see the problem in pursuing Ronald's injunction that you really can't understand these things without getting into the details. I'm being warned already about time. But you can have an independently owned regional that works for more than one airline on a multi-year contract, usually that compensates it for costs, but again, all the revenue and scheduling and branding features are controlled by the parent. The parent, at that point, the subsidiary has a completely independent labor contract. You can have an independently owned airline, as in for the one above, but that flies also its own brand service. So it flies branded service under contract, and it flies its own brand service on its own, and it has to have an arm's length, some sort of arm's length contract to the extent that those two services interact on a single passenger journey, but otherwise they do not have to have that interaction. And finally, you can have what amounts to simply a connection arrangement with an independent airline. They fly and price their own brand, they pay their own costs, they only share revenue on connecting journeys according to an arm's length contract that splits the revenue according to some negotiated formula. Now, you might ask, what accounts for the evolution from a single firm serving small cities to this huge cluster of institutional arrangements? Well, first of all, technology made a difference in the sense that as airplanes got bigger and faster, the airplanes you would use on low-density routes differed much more from the airplanes you use on high-density routes. A DC-3 had 21 seats, and it was used for most commercial transportation before World War II. The war accelerated development of airplanes by the time we were flying even in 46 and 47. Lockheed Constellations and DC-6s, they are longer-haul airplanes. They fly higher. They have 100 seats. They're not very good to drop into small towns. Secondly, there was regulation that very much limited what your network was. You had to apply to the CAB for routes. Your competitors got to protest your application or file parallel applications. Comparative hearings that were preposterous to a degree that I really won't waste your time describing this morning. Long Perry Mason hearings that ended up with the board in a closed room sending puffs of smoke up like the conclave of cardinals to announce which airline had been selected. The General Counsel's office was usually outside those discussions and was asked to craft an opinion that would explain the choice that had been made that would survive in the D.C. Circuit. And by the way, they had a tremendous track record in the D.C. Circuit because the record was huge and the statute allowed a lot of discretion. Internal pilot contracts became very important because as the airplanes became bigger and faster, pilots wanted a share of the benefits that were produced, and they negotiated for price discriminatory contracts. That is, for contracts that compensated them for their services on how capable the airplane was. They were, at the first introduction of the DC-3, there was an arbitrator's award in 1935 that established this principle. At that time, such regulation as there was of the flying was done by the Post Office and the ICC. By 1938, the CAB was in place. The basic formula, which is that the number of seats strapped to a pilot's rear end and how fast they're flying through the air, is the principal determinant of the relative compensation of pilots in the same firm, has survived to this day. Okay? It's reinforced by FAA regulation that requires every airline to have its own operating certificate and that requires its pilots to be qualified on its equipment using its procedures. That means even someone who has flown thousands of hours in an airplane just like yours cannot simply step into your cockpit in the event of a labor dispute or a labor stoppage. They have to be requalified. It's, by the way, not a dumb safety idea, but it has an important impact, obviously, on the mobility of labor resources. And while the CAB was in place, there was a lack of competitive substitution possibility limiting the compensation of pilots because you would have had to apply to fly the route and go through a 3-year proceeding, by which time the strike was almost certainly over. The airline was out of business. So this made labor contracts very important. The contracts were a function of union politics because internally it was hard to pay people flying little airplanes, little salaries, and people flying big airplanes, large salaries, when they all got to vote for the leadership of the union. In addition, marketing economies of scale and scope were limited by regulation, and then they've been exploited since deregulation. So we have some significant dates, just to give you an idea of the time scale over which this occurred. And they are simply 35, which is the arbitrator's award, 46, which is when large aircraft came into service, and the CAB set up a new class of carrier to fly small aircraft into smaller cities, and those were called local service carriers, later called regional airlines, and service began to be transferred. Up to that point, it had been to the advantage of airlines to fly as much as possible because they were being subsidized on a cost-plus basis, basically. As we moved through 1951, the CAB, first of all, it became technologically inconvenient to serve some of these cities. Secondly, the CAB started taking the big airlines off subsidy. So they wanted to get rid of flying that was not profitable. So from 51 on, routes are being shoved into the hands of local service carriers. You might say that that would present an enormous contracting problem, but it didn't, because the board had rules that said every airline had to accept passengers from other airlines according to a revenue prorate formula that was set by the CAB. In effect, they substituted a set of rules as a standard form contract for the interchange between airlines. And then in 1978, of course, we have deregulation. So the natural question, the sort of Coasean question, is what accounts for the current choices and for the current variety of arrangements. Well, it's important to understand that airline contracts are by their nature very incomplete. The airlines are trying to operate a regular schedule committed in advance, months in advance, in the face of stochastic variation, weather, maintenance events, congestion, and so on. And where connections are involved, the opportunity to be damaged by the failure of one's partner or to be damaged by a holdup by one's partner becomes very great. So you have the ability to impact the airline with which you're exchanging traffic. So after deregulation, airlines were free to make the Coasean choice. And a great deal of experimentation occurred. Labor contracts had involved, so it didn't make any economic sense for network airlines to fly less dense routes, but the marketing economies of scope and scale meant that they wanted them in the same system. So that's how, first they tried contracting with small airlines, and for a variety of Williamsonian reasons, that just didn't work. It was hard to do quality control, the contracts were necessarily incomplete, the incentives were not aligned very well, so a great deal of thought went into this. The first and most obvious thing to do was to start to fly wholly owned subsidiary, well, to fly the routes yourself with small airplanes. You couldn't do that without inflating the cost of flying those airplanes, because the labor contracts had to be kept sort of within political shouting distance of the folks flying the big planes, so you set up subsidiaries with separate labor contracts. You then discovered, as you saw on the earlier slide, that there were a variety of variations of that. But the important thing was that the separation of the two production activities, I won't make it a 1 minute only, but I'll try. The separation of the two production activities became important, while the separation of the integration of marketing activities became very important at the same time. So you wanted to have the American Airlines network or the Delta Airlines network or whatever, but the factories were these airlines that had these odd relationships to you, or many different kinds of relationships. So you were, remember also that the regional airline is very vulnerable. It's basically getting all of its revenue from the network airline. The network airline can claim breaches of contract and all sorts of things, hold up revenue, can make it difficult, more costly to operate by controlling the schedule and the degree of connection and all that. So what you have is basically conflicting and not quite reciprocal, because the network airline is probably more powerful, hold-up opportunities. And that's how you get into the business of supplying fleets, for example. You supply the fleet to the contracting airline so you can pull the fleet if the airline if that airline attempts to hold you up. You make the airline fly under your brand if you can, because you want it not to have an easy opportunity to set up independently, and you want to have it go through the expense of recontracting and repainting and all the rest of it if they move to someone else. So what's been going on is a tug of war between the need to integrate networks and the need to keep production as inexpensive as possible under the constraints of the regulatory and labor history that I've been talking about. So the natural question is, are there trends? And one answer is there are fewer wholly owned subs, and that's partly for capital reasons and partly for labor contract politics reasons. It's a lot easier. For example, American Airlines wholly owned sub actually has to have a conduit from its pilot seniority ladder into Americans. It's much easier, to the extent that these are independent firms, to avoid having to integrate in that way. By the way, needless to say, the American Airlines arrangement tends to escalate the salary of the people at the bottom. As I say, it has become an important trend that fleets are provided by network airlines, except for case 5 and 6. And there, the regionals have actually wanted, in some cases, where they're flying for multiple airlines and so on, they want to make themselves less vulnerable by supplying their own fleets, even when it's more expensive from a capital standpoint. And finally, there are recent attempts by regionals to operate networks under their own brand, that is, to evolve into 5, not so much 6, but to evolve into 5, and that is, again, an attempt to deal with these conflicts from the regional airline to defend itself from dependency on the network airline. I believe that does it, except for one final quote from the master. This, as you can see, I don't master this technology very well. And Ronald says that an account of the nature of the firm must be based on particular facts affecting the choice of institutions and realistic in that it corresponds to what's meant by a firm in the real world. And what I have attempted to do this morning, showing you more about this than you ever really wanted to know, is to show you what it looks like as you try to figure out why these production arrangements are as they are. If you like, I can, well, I suppose I have to start with Richard.
One of the things that you left out of this, which I'm a little bit puzzled by, is the Railway Labor Act, which in 1935 was extended to the airlines. And as you know, what that says, in effect, they can't strike in exchange for which you can't fire them. So that essentially fire, would you in fact still get the same constellation of network?
There are people in the airline business who believe that their problems are caused by the Railway Labor Act and who say that they would rather operate under the NLRA. I can't imagine that it makes a whole lot of difference. I think the most important leverage pilots have is the safety leverage I described, the difficulty of replacing them on short notice. Frank Lorenzo is the only guy who ever shut an airline down and tried to rehire an entire staff. It took him several years. He lost many hundreds of millions of dollars, and he ultimately went bankrupt. And his position was he was prepared to operate in a non-union way. The law didn't require him to operate in a union way. I think everybody in the business that I know believes that they have really no choice. They keep looking for ways to deal with the bargaining power of pilots. Some of them have fixed on the Railway Labor Act because it's what's different. It's hard for me to imagine. What the Railway Labor Act does, Richard, is it simply says contracts become amendable. They don't expire. When they become amendable, bargaining has to be taking place. At a point, the bargaining has to be in good faith. At a point where you think you have gone as far as you can, either the airline or the union has the right to petition the National Mediation Board, which is a political entity, and to declare an impasse. After an impasse, there's 30-day cooling off period, and then there's a strike. So it's not that you can't have strikes. It's not even that you can't have lockouts. It's that the process is a slow-motion ballet. You know, if you watch the auto companies negotiate under the NLRA, it takes years.
That was the question. Suppose you had neither of those two statutes.
What world are you living in?
Voluntary contract.
Yeah, well.
I'm curious, in that world, many of these problems would disappear.
Right, although the operational problems are real. There are good reasons for the FAA's safety rules.
I'm not denying that.
Yes, I'm sorry, could you tell me who you are?
Yeah, Mark Skousen.
Thanks.
So you've had deregulation since 1978. Is there any evidence that the regional airlines or the big airlines have reached any kind of equilibrium, profitable? How do you explain what appears to be a very unstable market? They're still going bankrupt. The profitability is like grocery stores. It seems to be very marginal, or am I missing something?
Well, you're asking a very interesting question that isn't exactly on this topic, but it's one I get asked by everybody since I had a great deal to do with airline deregulation. If you were adding up the numbers, I have both made more money for consumers and cost more money to airlines than most of the people in most rooms. First of all, the overhang of regulation was huge. All the firms were structured in ways that responded to the regulatory system. It has taken a very long time, and in most cases several bankruptcies, to unwind that structure. Secondly, the structure involved high enough costs so that there were new entrants available. And new entrants came in at lower cost, and then like Southwest Airlines, anyone who follows this business closely will tell you that Southwest now is much less different from network airlines than it was before. It has slightly more productive labor contracts left over. It has, by the way, a company union, Richard. It's an entirely unionized company. And the result is that basically you have an incentive for new folks to try because they can come in at lower cost than firms that have higher seniority labor. They keep trying to invent new business models, but as it turns out, the new business models don't work all that well in competition with hub and spoke networks. For example, JetBlue, which I have a great deal of respect for, discovered rapidly that there are only so many points in the United States you could fly between without connecting passengers. And at that point, their model was out of growth. They've moved to Boston. They've tried to organize more connections. They are becoming more like a network airline. Southwest is about to interline with WestJet and has talked about interlining with international airlines and so on. So the real network economics, economies. The problem is every one of these experiments costs money. That is, they cost money not only to the folks who run the experiment for themselves, but for the folks they run the experiment against. I believe that, in fact, in the current, Dick calls it a depression, I would call Great Recession, that the airlines are showing much behavior that promises a considerable amount of profitability in the future. For the first time, they have put airplanes on the ground. They have tried to keep them full, and when I say for the first time, in quantity. They have attempted to adjust supply to apparent demand. Some of it's hidden by the fact that people aren't buying airline tickets just like they're not buying anything else. Okay? But in fact, there's a fundamental change going on. You might say, what took them so long? And, the answer is you always had a story about why the other guy was dying. He was stupid or he'd done something wrong. I mean, this is part of what goes on inside a firm that's not captured in the marginal cost, marginal revenue maximizing model. There are assumptions about the way the world works that you fit yourself into. And it was easy enough for airline managers to decide that most of their problems were somebody else's fault.
Mike, I think that...
that was not Coasean, but it seems like this institutional factor of the labor contracts and everything is all what Coase was talking about.
No, I'm sorry. I thought I was doing echt Coasean work.
Yeah.
I thought I announced that it was particularly Coasean.
Mike, I think we're running out of time, so our audience has earned its lunch.
Oh, I thought we went to 12:45. No?
12:30. Thank you very much.
Very sorry.